Federal agents watched a 19-year-old walk away with 2 AK-47-style rifles and 500 rounds of ammunition, and they let him take them. According to the Justice Department, that moment was the final step in an undercover operation built to stop an attack timed for the one day when American crowds gather to vote. What the government says happened next ended with a courtroom, a 15-year sentence, and a promise that the man responsible would never legally live in the United States again. This is the case of Abdullah Haji Zada, and by the time you're done watching, you'll know what prosecutors say he planned, how federal agents caught him before he could act, and why the sentence he received is already the maximum the law allows. That last part raises an uncomfortable question about whether the maximum is enough. Here's what the Justice Department says. In the order, its own press release lays it out. In October 2024, the FBI and the Oklahoma City Joint Terrorism Task Force arrested 2 Afghan nationals. That task force is a standing partnership between the FBI and local and state police, built to investigate and disrupt terrorism plots before they happen. One of the men arrested was Abdullah Haji Zada, then 17 years old, a lawful permanent resident of the United States. The other was Nasir Ahmad Tawhidi, 28. Prosecutors say the two had acquired 2 AK-47-style rifles and 500 rounds of ammunition, intending to use them in a mass casualty attack on a crowd in a U.S. city on Election Day, November 2024, in the name of ISIS. I went through the Justice Department's public statements on this case, and one detail kept standing out: the timeline. The arrest happened in October. Weeks before the vote, it was allegedly timed to disrupt. That's not luck. That's what a disruption operation is supposed to do. End a plot before its target date arrives, not after. Here's where the case gets legally complicated, and it's worth walking through because it explains why sentencing took over a year. Zada was 17 at the time of his arrest, a minor. Under federal law, prosecuting a minor as an adult for a terrorism-related firearms offense isn't automatic. It requires specific legal steps, and those steps took time. Zada didn't enter his guilty plea until April 17, 2025, 6 months after his arrest, and he entered it as an adult to 1 count of conspiring to receive and possess firearms and ammunition in connection with a federal crime of terrorism. His co-defendant, Tawhidi, followed 2 months later, pleading guilty in June 2025 to providing material support to ISIS, a separate and more serious charge that the Justice Department says carries up to 35 years when combined with related counts. That's the first real obstacle in this case. 2 defendants, 2 different charges, 2 different plea timelines, and one of them a minor whose prosecution had to clear a legal bar the other didn't. Prosecutors resolved it by pursuing each man on the specific conduct the evidence supported, Zada on the weapons conspiracy, Tawhidi on material support, rather than forcing both into an identical charge the facts didn't equally fit. Once the guilty pleas were entered, the investigation's findings stopped being allegations to be proven at trial. They became facts the defendants had admitted to in federal court. What remained was sentencing. Zada's plea settled the outcome of the weapons charge. What wasn't settled yet was the number attached to it. And on November 20th, 2025, a federal judge in the Western District of Oklahoma gave him the answer: 15 years, the statutory maximum for the charge he pleaded guilty to. 15 years is a specific, deliberate number. It isn't a judge picking a figure that felt right. It's the ceiling Congress built into the statute Zada pleaded guilty under. A judge handing down the statutory maximum is saying, in effect, that within the charge actually brought, the law has nothing higher left to give. John A. Eisenberg, the Assistant Attorney General for National Security, said in a statement following the sentencing that Zada was welcomed into the United States and provided with all the opportunities available to residents of our nation, yet he chose to embrace terrorism. That's the government's framing, a resident who prosecutors say turned an offered opportunity into a plotted act of mass violence. Here's what strikes me about that statement and about this case as a whole. Zada wasn't radicalized in a training camp overseas. He was a teenager living inside the United States as a lawful resident. Federal counterterrorism officials have been describing this pattern for years, not infiltration from abroad, but the remote radicalization of people already here, reached through encrypted messaging and propaganda that doesn't need a passport to cross a border. Whatever else this case is about, it's a data point in that harder problem, an ideology that doesn't need to smuggle anyone in because the internet already got there first. Let's talk about the part of this case people don't say out loud very often. 15 years is the legal maximum for the charge Zada pleaded guilty to, but it's a ceiling set for receiving and possessing firearms in connection with terrorism, not a charge that directly measures the human cost of a mass casualty attack on an election day crowd that, according to prosecutors, never got the chance to happen only because agents intervened first. Some will say 15 years, for a plot of that scale, is too light, that the statute needs a higher ceiling for weapons tied to intended mass casualty terrorism. Others will point to Zada's age, 17 at the time, and argue that even the maximum available was already the harshest outcome the law allowed for a minor swept into someone else's plot. I'm not going to pretend there's an obviously correct answer here. Both readings are defensible, and that tension is baked into the sentence itself, which brings up a real question worth sitting with. If you were the judge in that Oklahoma courtroom, weighing a 17-year-old's age against a plot aimed at a crowd on election day, where do you land? Is the statutory maximum enough? Or does a case like this argue for Congress to raise it? That's not rhetorical. It's genuinely unresolved, and reasonable people land in different places. There's broader context worth understanding here, separate from Zada or Tawhidi specifically. Joint terrorism task forces aren't a recent invention. The first one formed in New York in 1980, long before most people watching this were born, and the model expanded sharply after September 11, 2001. Today, more than 200 joint terrorism task forces operate across the country, coordinated nationally through the FBI's National Joint Terrorism Task Force at headquarters. They exist because terrorism investigations sit at the intersection of federal and local jurisdiction. A plot can be planned locally, funded internationally, and executed against a target that's purely domestic, all at once. The FBI leads these task forces, but they run on local and state officers who know the ground the plot would actually unfold on. That structure is what put Oklahoma City police and federal agents in the same room on this case, instead of two agencies working the same plot separately and comparing notes too late. Most people assume a charge like providing material support to a terrorist organization is a newer legal tool, built after 9/11 specifically for cases like ISIS recruitment. It isn't, not entirely. The statute traces back to the Anti-Terrorism and Effective Death Penalty Act of 1996, and it was substantially expanded after 2001. The Supreme Court upheld the material support statute's constitutionality in 2010 in Holder v. Humanitarian Law Project, rejecting a First Amendment challenge to the law. That history matters here because it's the exact legal foundation Tawhidi's charge rests on, a statute that's been tested, litigated, and upheld, not an improvised label attached to whatever a defendant is accused of. The material support charge Tawhidi pleaded guilty to is one of prosecutors' primary tools in cases like this, because it doesn't require the government to prove an attack was carried out, only that someone knowingly provided support, resources, or personnel intending to further a designated terrorist organization's goals. That's a deliberately broad net, built for the kind of case where the attack never happens because it's stopped first. Put yourself for a second in the position of the agents running this task force in the fall of 2024. You're not just trying to prove someone said something extreme online. Plenty of people do that and never act on it. You're trying to build a case solid enough to survive a federal courtroom based on physical acquisition of weapons tied to a specific date on the calendar. Wait too long to intervene, and the risk is obvious. Move too early, before intent is provable, and the case can collapse or the charge ends up weaker than the conduct deserves. According to the Justice Department's own account, this one ended with an arrest a month before the date in question, neither too early to prove intent nor too late to prevent the act. The weapons charge Zada pleaded to works on similar logic. It's not a general firearms charge. It specifically covers receiving or possessing firearms and ammunition in connection with a federal crime of terrorism. Prosecutors have to connect the physical act, buying rifles, buying ammunition, to the intent behind it. That connective tissue is often the hardest part of a case like this to prove, and it's usually where an undercover operation, confidential sources, or monitored communications do the real evidentiary work, even when a press release doesn't spell out exactly how. That's worth saying plainly, because it's one of the genuine limits of what's public here. The Justice Department's press materials confirm the weapons, the timeline, the charges, and the sentence. They don't spell out, at least not in what's been publicly released, exactly how agents first identified Zada and Tawhidi, whether an informant or undercover employee was involved in the weapons transaction, or which specific U.S. city was the intended target. Those details may exist in sealed filings, in sentencing memoranda that aren't fully public, or may simply not be part of what the government has chosen to disclose. I'm not going to guess. If the facts aren't public, I'll say so instead of filling the gap with something that sounds good on camera. What is public, and worth stating plainly, is where things stand with Tawhidi. His guilty plea in June 2025 was to providing material support to ISIS, a charge the Justice Department says carries a combined maximum of up to 35 years alongside related counts. As of what's been publicly reported, his sentencing has proceeded on a separate track from Zada's, a reminder that even co-defendants arrested together on the same day for the same underlying plot can move through the federal system at entirely different speeds depending on the specific charge each one faces. One detail in the sentencing coverage stuck with me more than the others. As part of his plea agreement, Zada didn't just accept a prison sentence. He stipulated to a judicial order of removal, meaning that once his 15 years are served, he will be deported to Afghanistan, the country he left as a young, lawful resident of the United States. There's no ambiguity in that part of the outcome. It's not a possibility prosecutors are still pursuing. It's already agreed to, in writing, as a term of the plea itself. The harder part is the months of legal process afterward, converting a minor's arrest into a chargeable adult case, sequencing two defendants through separate plea negotiations, and building a sentencing record solid enough that a 15-year statutory maximum survives appeal. None of that shows up in a headline. All of it is why an October 2024 arrest didn't produce a final sentence until November 2025, more than a year later. So where does that leave the actual open questions? First, which U.S. city was the intended target? The public record I reviewed doesn't specify one, and I'd rather tell you that than invent a name that sounds plausible. Second, the exact method investigators used to first identify the plot, whether it began with a tip, a monitored account, or an undercover purchase, isn't detailed in what's been made public. Third, Tawhidi's own sentencing outcome, which, as of this video, hadn't been finalized in the same public reporting that covered Zada's case. If you go looking for updates, the Justice Department's Office of Public Affairs press releases and the U.S. Attorney's Office for the Western District of Oklahoma are the primary sources, not secondhand summaries, the actual releases. I should say this clearly too, because it matters even after a guilty plea. The plea and the sentence resolve the legal case as charged. They tell you what these two men admitted to and what the court decided as a result. They don't retroactively make every unconfirmed detail floating around online true. Stick to what the record actually says. That's the whole discipline of covering a case like this, honestly. I cut a few procedural details from this video for length, specifically the exact statutory language of the federal crime of terrorism firearms provision Zada pleaded under. If you want that broken down in a follow-up, comment statute, and I'll consider it for a future video. Here's where this actually lands. A plot aimed at an election day crowd, disrupted before it could happen, ending in a 15-year sentence for one defendant and a still unfolding case for the other. The government calls it a resident who chose terrorism over the opportunities he was given. The sentence calls it the maximum the law allows. Whether that's the same thing as justice is the part I'm leaving with you.